the Texas Trial Lawyers Association and here in favor, testing in favor of House Bill 3984. This has a Senate companion, which is Senate Bill 232. This bill is a solution that is being asked for by specifically the Dallas Court of Appeals and other courts of appeals. This has been a solution that even asked for by the Texas Supreme Court. Chapter 74 is open to interpretation as to what is a health care liability claim. And unfortunately, there are cases as variable as rape in nursing homes, spider bites in nursing homes, broken glass in showers that have been left to the question of whether they qualify as a health care liability claim or not. All this bill does is allow that dispositive question to get answered for both parties to the case so that the expert report requirement of Chapter 74, which is dispositive, the parties can know where they stand on the issue. So if you've got a case, for example, the Dallas case dealt with transition of a patient out to the parking lot in a wheelchair. And the question was, there's no way for us to determine if by judicial finding this is or is not a health care liability claim. So do you get a report that it's violation of standard of care to drop somebody out of a wheelchair, or do you not? Because if you don't, and it is, then the case is gone. If it isn't, then you live to fight another day. So all this bill does is get that judicial determination. We're not great with some of it. The constituency from the other side asked for interlocutory appeal. That's not my favorite thing, but we've agreed to that. There's timelines that are pretty onerous that have been requested by the constituency other side. We're not exactly great with that, but we're still good with the bill. And so we appreciate your consideration.
Any questions for Representative Schofield?
Mr. Perdue, we just got the committee sub, and can you tell me the difference between the committee sub, and if you don't, that's fine. Can you tell me the difference between the committee sub and the bill as filed?
Yes, sir. So the bill as filed was a very simple mechanism, perhaps in two and a half pages, to get the determination made. And so it did simply create this section that would allow for either party to request a judicial determination of whether this is or isn't a health care liability claim. It didn't really have a timeline for that ruling. It did not have any permission for an interlocutory appeal process of that determination. And it didn't have the sliding timeline for the provision of an expert report tied to the hearing, the finding in that determination. So the bill has supplemented for the timeline for when you get a report based on the hearing. It is provided for an interlocutory appeal that was sought for by the defense side to these cases, and additionally just clarified that you've got to get a ruling on this, or in this committee substitute, the default is if the court does not make a ruling, then by fiat it becomes a health care liability claim, and those are the changes.
Yeah, my concern with the filed version was it sort of undercut the whole idea of doing this up front. And you're saying that I haven't had a chance to review it yet.
Yeah.
You're saying we built some things in to kind of make the decision get done up front.
This very clearly is going to get this on the table and get it ruled on. And if it's not ruled on by the judge, the last fix that was put in yesterday is
within 90 days.
Within 90 days, if it's not ruled on by the court, then the default setting is it is a health care liability claim. I think that just gives clarity for both parties, whether plaintiff or defendant.
Thank you.
Any other questions? Okay, thank you, Mr.